Governor Roy Cooper has spent nearly a year shutting down and then reopening much of North Carolina's economy, and he's based his decision on powers granted to his office by the State Emergency Management Act. Well, there's been some dispute about whether the governor has complied with that act's provisions. Regardless of that legal question, our next guest argues that now is a good time to amend the Emergency Management Act. John Guze is Senior Fellow in Legal Studies for the John Locke Foundation, and he's written a series of Locke research briefs talking about amending the Emergency Management Act. He has a new one that offers some specific recommendations. John, welcome back.
Thanks, Mitch.
So before we get into some of the specific recommendations, remind us generally why you think it would be a good idea for the General Assembly to take a closer look at this Emergency Management Act and make some changes.
Well, I think what I've seen over the last year, we've all seen this, is that the COVID crisis has revealed some weaknesses in the way the act is written. And the biggest one is that we don't have enough provisions in there to ensure that the act does what it's supposed to do. You know, in the course of this crisis, I think a lot of people didn't think about it, but the fact is, under our system of government, we have what's called a separation of powers. And it's very important. It's one of the fundamental principles upon which the state is based. And what it says is that the power to make laws and to make rules regarding conduct that are backed up by legal sanctions, that's the exclusive province of the state legislature, the General Assembly. The governor has no power to make laws, or he shouldn't under our Constitution. We do make some exceptions for that. And one of the exceptions is when there's an emergency. And it's important to remember why. Why do we have the Emergency Powers Act? Why does the General Assembly delegate some power to the governor to suspend laws or to make new laws when there's an emergency? The reason is simply that sometimes these things happen so quickly that there's not time for the General Assembly to meet and deliberate and enact new regulations and laws. So we pass that power on to the governor. But this crisis has been going on for almost 11 months, maybe longer, depending on when you want to start it. We've had emergency orders in place for more than 11, or well, for more than 10 months for sure. And that's not what we mean when we talk about an emergency. 10 months is plenty of time for the legislature to call an emergency session if needs be, get together and figure out how to respond to this ongoing situation, dire as it may be.
And in your latest Locke research brief on this topic, you actually go through the Emergency Management Act and specify several places where there could be some good changes that would help clarify this issue. Let's look at them. First one is the definition of emergency itself. You think that there should be some language inserted that explains that something that goes on for this long can't be considered an emergency.
That's right. I think it's important just to put that in there as a reminder to all the parties involved, including the courts, whenever these things get litigated, that an emergency is something that happens very quickly and needs an immediate response. Something that goes on month after month is not an emergency within the meaning of emergency in the case of the Emergency Powers Act. And it's not something that we should just accept as normal for the governor to rule by decree for almost a year.
The next section that you target takes a look at the process of extending or ending an emergency. And you would really like to see some language in there that inserts the General Assembly back into that process, that if an emergency is going to be extended, or if it's going to be ended, it can't just be the governor.
That's right. Well, there's two things about this. In fact, first off, there should be an automatic limit on the period of time during which a declaration lasts. I think I suggested 30 days. Different states have different periods, and we could debate about what the exact period should be, but the point there is simply that it's not indefinite. An emergency has to come to an end at a certain fixed time unless it gets extended. And here's an important, I think, what was definitely a flaw in the act. Most states say that it's up to the General Assembly or the state legislature to extend an emergency, but ours doesn't. It says that only the governor himself, it's entirely up to the governor whether or not to extend or end an emergency that he declares. So I think those are two things that we need to fix.
Moving on, you also take a look at local emergencies and would like to see something in the Emergency Management Act that inserts the General Assembly's role in case of local emergencies.
Again, and for the same reason, an emergency isn't an ongoing condition that society has to cope with. It's something that is immediate. And there's no reason why local authorities should have any more power than the governor to keep an emergency going on their own initiative without approval from the legislature.
The shortest recommendation in your latest report is get rid of the price gouging mechanisms in here.
Right. I suppose that will be the least popular. Everybody has a gut feeling that there's something morally wrong with people, as it might be bringing in ice from out of state or uh, flying in to provide services that are in short supply. It feels wrong to us, but the fact is, this is how a market works. When there's a shortage, prices can go up, and that draws in more supply. We don't want to stop that. Least of all, when there's an emergency, we want as many people to come and help us as possible. So I think we should just dispense with that.
The last specific piece of the Emergency Management Act that you look at is one that has really come into play this time around, and that is you'd like to limit the governor's ability to substitute his control for local control, which is something that he's used during this COVID-19 situation to bypass another part of the act that requires him to get the concurrence of the Council of State, the 10 elected statewide executive branch officers. You'd like to see some language in there that limits how the governor can bypass that statewide emergency by trying to take over local governments.
Yeah. So, and before I get into that, let me just point out there are some very good things about our act that not every state has. One of them is a provision that says that any executive orders the governor should issue during an emergency have to be apply equally. He can't discriminate against one kind of institution. We've seen that come up with things like bowling alleys and church services and things. These things have to be handed down even-handedly, and that's already in there, and it's good that it's in there. But another very good provision, the act, the way the act is set up, the governor's powers are provided in three separate sections or subsections of the act, and one of them has a list of basic powers the governor gets during an emergency. Those are very limited. Then it says, with Council of State concurrence, he has a whole bunch of other powers to do more extreme things, like the things he's done. Force people to stay indoors, close businesses, control how much people can move about, all those kinds of things. He's only supposed to do that with Council of State concurrence. The problem we've seen, or at least I think it's a problem, is that there's another provision that says if the governor determines that local control of the emergency is insufficient, he can exercise powers that are otherwise delegated to municipalities and counties. He's interpreted that to mean, since this is a statewide emergency, no local government, no county, no city can deal with it on their own. Therefore, he can assume the powers of all the counties and all the municipalities and impose statewide lockdowns and other executive orders applying to the whole state. I think that's a tendentious reading of the act. I don't think that'll stand up at the end of the day if it gets as far as the Supreme Court, but it's still, the act as it's written is ambiguous enough to make that a plausible reading. I think they need to tighten up the language of those sections to make it clear that anytime the governor wants to act in an emergency and impose extreme measures on the whole state, he has to convene the Council of State. They have to work together, ignoring partisanship, getting input from members from all over, from elected officials from all over the state, and work together to come up with a plan. He can't simply evade that requirement by citing this other section on the local authorities. And as far as local authorities are concerned, while it does make sense that if they're not up to the job, he can go in and do what they aren't doing adequately, but he can't just use that as a pretext to evade the Council of State concurrence requirement.
Now, everything we've talked about so far involves changing the language in the existing Emergency Management Act. You end the piece basically with another suggestion for an amendment that would clarify the importance of protecting people's rights and making sure that there's some recognition that people have rights, and that if the government is going to be trampling those rights, so to speak, that it has to be narrowly tailored, limited basis, and can't last indefinitely.
Right. So one of the other things that's come out, and this isn't just in North Carolina, all over the country, we've seen courts really grappling with the question of what happens when there's a constitutional right, like the right to bear arms or the right to religious observance. What happens when these things get restricted by emergency orders? What standard does the court apply? How carefully should the court um, defend those rights, or to what extent should the court simply defer to the executive officer involved? In our case, it's the governor, and say if he thinks this is right, then it's probably okay. As time is at the beginning of the pandemic, the courts were almost always just completely ready to defer to state governors, even when it came to things like a religious observance, because they felt, well, it's an emergency. He's on the ground there. He knows what needs to be done. As time has gone by, though, we've seen this more and more, especially just recently at the US Supreme Court. The courts are starting to say, now, wait a minute. These are constitutionally guaranteed rights. We have to take a hard look. We have to apply what's called, we have to look at them strictly to see whether they really do need to do this, and whether this is the least restrictive way to do it, and whether it conforms with the guarantees in our federal, and in our case, in our state constitution. I'm suggesting that maybe we ought to add a section to the act that says where constitutional rights are concerned, these things have to get, the governor can only do these things if it's really necessary to accomplish a compelling government purpose. And that would be a signal to the courts that when people challenge these, that's the standard they have to apply.
So obviously, this is going to take some work if the General Assembly wants to do this. If lawmakers leave the Emergency Management Act as it is, don't make any of these amendments, what kinds of problems do you foresee?
Well, a lot of it will depend on whether we have another crisis like this. God, we must pray that we don't. But if we do, it'll be down to the next governor. Now, there are some lawsuits, there have been some lawsuits, and there's some lawsuits pending that bring up some of these things, and including this problem with the using the local authority insufficiency as a pretext for going around the Council of State concurrence requirement. That could conceivably get resolved in the courts sooner or later. And if the courts decide the way I think they ought to decide, that might solve that problem without amending the act. Same thing could happen with regard to what standard of review applies to emergency orders that on their face violate constitutional guarantees. But I don't think we ought to wait for the courts to have to wade in on this. And we don't, especially because oftentimes the courts will take these things up on a as applied basis. So they might get a decision that's favorable to one particular bar owner or one particular congregation. But we want these things resolved once and for all so that nobody has to go through the courts to get their rights preserved in the future.
Well, we know one person who's going to be watching very closely as all of these legal issues progress through the court system is John Guze. He is Senior Fellow in Legal Studies for the John Locke Foundation. John, thanks so much.
Thank you, Mitch.